Navarro. Sitting to my left is the Honorable Joanne Vogt, and my name is Rebecca Freyre. Both counsel are present, I see, and ready to go. Thank you. I want to ask whether either counsel has any questions about the oral argument procedures that you should have received a written copy of.
No questions, Your Honor. Thank you. No, Your Honor.
All right, great. Before we get started, I just want to let both counsel know that there is a toggle switch on the podium on the right, kind of down low. So take your time, adjust the podium as you need to. Please enter your appearance with your full name and your attorney registration number before you begin your argument. The timer will not begin until after you have entered your appearance. We are live streaming these proceedings, and for that reason, we ask that everyone in the courtroom please turn off any electronic device that you have, even putting it in airplane mode or turning on the vibrator can interfere with our equipment. Also, please be mindful, because we are live streaming, of any information that you don't want released to the public. Anything you want to keep confidential, make sure you don't mention it. With that, I think we are ready in the case of Brown versus Hall. Counsel, you can proceed when ready.
Good morning, Your Honors. My name is Colin Campbell, registration 12193, and I am arguing on behalf of Appellant Cheyenne Hall. We have three issues that we've raised on appeal. Time is short. I don't know that we'll have the opportunity to discuss all three, so if the panel has particular questions with regard to one issue more so than the others, I'm happy to tackle that first. Otherwise, if left to my own devices, I'll start with the issue of whether Medicaid fits within the contract exception to the Colorado source statute, because that's the one that probably has the broadest implications. I realize that when we ask this division to depart from last year's Pressy decision in favor of the prior Gomez versus Black decision, that is a big ask. Judge Navarro, I'm asking you to reconsider your opinion in Pressy, and I recognize that if this division were to go in favor of Gomez, that creates additional uncertainty in the law, which is never the goal, certainly, in these proceedings. Nevertheless, I think that the trial court's reasoning in its initial order in this particular case gives good cause to perhaps further examine that issue. Because what Judge Taylor recognized in analyzing the issue is that when the Medicaid applicant acknowledges in the Medicaid application that they are to repay Medicaid benefits out of the proceeds of any claim against someone who may have been at fault in causing their injuries, as Judge Taylor described it, that recipient does not make any promise to their detriment. They are not agreeing to pay any money. They're not agreeing to provide any services. They are simply agreeing to forego a windfall. And as Judge Taylor described it, foregoing a windfall does not create consideration.
Mr. Campbell,
Yes.
Weren't there actually a few more promises in the Medicaid agreement at issue here that go beyond the obligation under the subrogation statute? For example, you assign my right to appeal and a few other things like that. Can we really say that upon signing this, Mr. Brown didn't at least give up a few rights that he otherwise would have had?
Well, the Pressy decision didn't go beyond acknowledging just the simple obligation to repay. But I think perhaps more to your point, and the secondary and perhaps more persuasive reason why we may want to more closely examine this issue is that Mr. Brown had no right to retain the money regardless of what was written into the Medicaid application, because Medicaid has a statutory lien, a statutory right of recovery that obligates the parties to satisfy the lien. So the application doesn't give up anything, any rights that Mr. Brown or any other Medicaid recipient would have under the law.
Do you recall whether you flagged that statutory right in the trial court? I noticed you didn't get to it here until your reply brief.
I did not. So that, I agree that that was not part of Judge Taylor's reasoning. But I think nevertheless, it's something that this court can certainly consider in evaluating whether there's more issues here that come to bear beyond those that were addressed in Pressey. The analogy that comes to my mind is that if I obtain a Colorado driver's license, I'm expected to follow the traffic laws of Colorado. But that doesn't create a contract. There's no consideration, because I'm obligated to follow the driving laws of Colorado, whether I'm driving under a driver's license from another state or one from Colorado or none at all. So because Mr. Brown did not give up any right by the Medicaid application that he would have under the law regardless of that, I think under any traditional analysis of what comports with actual consideration, there was no consideration. That this is purely a gratuitous governmental benefit, which is the way our appellate decisions had recognized it, either in passing or in dicta, or more directly, as in Gomez versus Brown. So it's for those reasons that I ask, again, I realize I'm asking a lot, but I think it is warranted under the law that perhaps you take another look at this issue, and that from my view, there's good cause to conclude that Gomez actually got it right the first time.
Mr. Campbell?
Yes, sir.
If we agreed with you, wouldn't we be injuring the policy of the Medicaid payback provision? Because if we agree with you and the judgment is reduced by whatever Medicaid paid, how is Medicaid going to ever get paid back?
That's been addressed in some trial court decisions, and I recognize it wasn't really framed in this case, but some of the trial court decisions that have tackled that one have said, well, it's up to Medicaid to pursue their subrogation rights if they choose to do so. But what that really speaks to is what the methodology would be of what is the set-off. Are you reducing it by the entire amount of the medical bills that were satisfied, or are you reducing it just by the difference between that and the amount of the actual Medicaid payment so that amount can be repaid? I realize those are all important ancillary issues, perhaps not framed thus far in this case. If this court would like additional briefing on that particular issue and the implications that are raised by that question, I'm more than happy to do so, but I recognize that really hasn't been delved into in the briefing thus far.
Thank you.
Turning to our second issue, Dolores DeLoe was our medical billing expert, and Judge Taylor did not allow her to testify. As you've seen from the transcript, his analysis was that the phrase reasonable and necessary, which is an element of proof for recovery of medical expense damages, in his view, really should be interpreted to mean reasonably necessary. In other words, a defendant has to challenge whether the medical treatment was necessary. And if they acknowledge that it was, then the defendant may not challenge through expert testimony or otherwise whether that particular bill was reasonable. I think the parties are in agreement that was in error, that Colorado law from Safeway versus Lawson forward has consistently recognized that the reasonableness of a medical expense is an element of proof and an element that is subject to challenge by a defendant. And so if we start with that premise that Judge Taylor's initial premise in that regard was flawed from the beginning, then my question would be, well then, in what way was Ms. Defoe's testimony objectionable? Because what she did was provide a point of comparison, that this is what the 75th percentile is and the 90th percentile is of what other providers in the same community charge for the same services. And specifically, as was demonstrated in the questioning during the transcript, her analysis was in no way dependent upon insurance. It did not take into account amounts paid for those services. It focused exclusively on the amounts charged by providers in the community. Now, plaintiff says that Judge Taylor made the right decision for the wrong reasons, and they point to the fact that Ms. Defoe did not expressly or express an opinion that any particular charge was per se unreasonable. But my reaction to that is, while an expert can opine to the ultimate issue of fact, there's certainly no obligation to do so. And to me, it's the difference between an expert telling the jury what to think and providing useful information for the jury to take into account in making up their own mind as to whether a particular element has been proven. And I can't think of what would be more relevant to the question of whether a particular medical expense is reasonable than comparing it to the averages and 75th and 90th percentile points of comparison for what other providers in the same community charge. Now, Judge Taylor expressed he was reluctant to do so because if he allowed the testimony, that would be inviting the jury to independently assess each medical charge to see whether it was reasonable. And I say, well, that's exactly the point. That is precisely what it is the jury's obligation to do.
Mr. Campbell, your argument certainly is logical, but I'm not sure what we are to do with the Supreme Court's statement in Crossgrove that says, and I'm quoting, admitting amounts paid evidence for any purpose, including the purpose of determining reasonable value in a collateral source case, carries with it an unjustifiable risk that the jury will infer the existence of a collateral source from the evidence.
The reason why I don't think that that's on point here is because Ms. Defoe's testimony wasn't based upon amounts paid. It was completely divorced of any consideration of amounts paid, either specifically with regard to these particular charges or with regard to her database that she's using. She was basing her opinions solely upon the amounts charged by providers in the same community for the same services. So I don't think that that instruction in Cosgrove in any way gives cause to preclude her from testifying. Does that address the question?
I understand your response.
Okay. So in effect, what Judge Taylor's ruling did was prevent us from providing relevant evidence from which to allow the jury to independently assess whether or not all of the charges were reasonable. Courts have consistently, trial courts, appellate courts, I think there's been clear consensus that permits a defendant to put on evidence to challenge the reasonableness of a medical charge. Well, if Ms. Defoe's testimony is held inadmissible, then under what circumstances could a defendant ever challenge the reasonableness of the charges? This is testimony that is tailored to fit within the limitations and provisions of Cosgrove and other cases that speak to this. So if she's not allowed, then basically the net effect of that is to tell a defendant, you simply have to accept the charges as billed, and you are without recourse to provide the jury any point of comparison you are precluded from making any argument that these bills are, in effect, excessive. And so-
Counsel, I have one question. Mr. Brown, however, had no control over what he was being charged. And if those charges were medically necessary, if the treatment was necessary, wouldn't this be a litigation between the or the defendants and the providers? I'm not sure how Mr. Brown, or why Mr. Brown should be saddled with reasonableness and getting reduced damages, because he had no part in this. Do we have the right parties?
And I think that your question speaks to part of Judge Taylor's analysis. I mean, I think he basically said essentially the same thing, that Mr. Brown had no control over the choice of his doctors. My answer is that Safeway versus Lawson and any progeny don't draw that distinction. And they don't say that a defendant can challenge reasonableness only if the plaintiff personally selected his own medical providers.
Would you agree that it would be different if Mr. Brown had said, I want that private suite at this hospital, I know Medicaid doesn't cover it, or Medicaid doesn't cover it, but he wanted to be in the private suite for 2 months, and it cost extra money? Wouldn't that be a different factual scenario?
It would make my case easier.
Okay.
But I wouldn't be able to draw the point that he's going beyond Medicare, because I'm not allowed to talk about Medicare. So you still have to look at each medical charge for its own sake. And either this is reasonable or it's not. And to make that determination divorced from payment considerations, insurance considerations, Medicare or Medicaid considerations, which is what we were doing.
Right.
Looks like I'm out of time. Thank you all.
Thank you.
Good morning, Your Honors. My name is Jason Alleman, number 42570, and I represent the appellee, Nicholas Brown, and I'm joined by Cameron Hunter, number 50095. And Your Honors, we would respectfully request that you affirm the trial court's rulings in this matter as supported by Colorado law and the facts of this case. And I'll address I'll address the issues in this case in the same order that Mr. Campbell did. The first issue is whether or not the Medicaid benefits that Mr. Brown received should fall under the contract exception of 1321.111.6. And I would argue that the ruling that that Judge Navarro and the panel in Pressy reached was well reasoned and well regarded. The contract exception exists, and Medicaid benefits are paid for applicants that are required, and they're required to enter into a written Medicaid application agreement to repay the state for any Medicaid benefits that they receive. And also, as Judge pointed out, they also agree to do other things, such as immediately notify the state of any medical claims or lawsuit, and cooperate with the state to help collect any benefits that are paid out. And what I would point out is the appellants here are trying to say that no consideration was given for these benefits. And I would argue that under Volunteer Garden-Schwartz and Van Waters, the courts looked at this issue and said that some form of consideration is adequate to satisfy the contract exception. And it doesn't have to be in the form of monetary payments. And if you look at Colorado law and what constitutes consideration, especially if you looked at Luke's Concrete Pumping v. Horner, it says any benefit to a promisor or any detriment to a promise at the time of the contract, no matter how slight, constitutes adequate consideration. And consideration may take the form of forbearance by one party to refrain from doing something that it is legally entitled to do. And I would argue that that's exactly what happened here. Nicholas Brown agreed that as part of the Medicaid benefits he received, that he would repay any benefits paid to him as a result of a claim or a lawsuit. As slight as that may be, if someone chooses to look at it that way, that constitutes consideration, and that forms a contract. And I think actually the appellants here are trying to carve a a pretty narrow exception into what's considered consideration under Colorado law, considering the cases I cited in my brief for the appellee. I would also argue that appellant argues that, well, there's no consideration because Mr. Brown would have been required to repay these benefits because of statutory provisions. Well, this case law establishes that just because you receive a benefit from a governmental source doesn't mean that it's not a collateral benefit in any way. In fact, it's recognized that under workers' comp benefits, that falls under the contract exception. And a case that just came out last Thursday, I'm sorry, I would have filed a supplemental pleading, Forfar v. Walmart, that's 2018 COA 125, that also expressly held that Medicare fell under the contract exception for 1321.111.6.
Was that a workers' comp case?
No, it was a Medicare case.
Medicare case.
But Medicare has the same type of statutory requirements, that if you do receive Medicare benefits, you have to pay that back. So, and also that a Forfar is kind of relevant, I think, because they also cite Pressey and Judge Navarro's opinion with a positive light, with acceptance, building upon what Pressey has already built. And I would just offer that it would be a huge detriment to the development of law in Colorado to take a step back and to issue a ruling that conflicts with Pressey. As I argued in my brief, Pressey is just the logical conclusion of the development of the law in Colorado. In Smith v. Kinningham, the court recognized that that Medicaid falls under the pre-evidentiary or pre-verdict evidentiary component of the collateral source rule. And Pressey was just simply the logical conclusion of that development in Colorado law. One party has to reap the benefit of Medicaid here. Either it's going to be the plaintiff who gets that benefit for Medicaid covering the medical bills and being able to recover those medical bills, or it's the defendant who gets those bills entirely wiped out because it doesn't fall under the contract exception. And under the law, under the collateral source doctrine, we know that the preference of the Supreme Court is that benefit goes to the plaintiff. And Mr. Campbell pointed out, well, Medicaid has its own rights. They can go themselves and go try to collect that. Problem with that is, imagine the cost of the state if they had to go after every single, there are so many personal injury cases, and for the state to have to mobilize, hire attorneys, enter a motion to intervene in all those cases, I just don't think would be sustainable. I think the system, the way it is the Medicaid applicant and recipient has to pay back Medicaid for the amounts that are paid. And that's one thing, when 1321.111.6 was enacted, one of the reasons it was to prevent the plaintiffs from receiving a windfall. Well, here, and in Crossgrove, one thing that's discussed is, well, there's actually not a windfall because the plaintiff actually has to pay back the benefits. That's exactly what happens here. Is Appellant Brown has to pay back the Medicaid benefits that he was given. There's no windfall. And if there was, the law under the collateral source doctrine says that it goes to the plaintiff, not to the defendant.
Counsel, could I ask you more about your consideration argument? So hypothetically, if someone lent me or gave me $1 million and says, it's a gift, you don't have to pay me back unless you win the lottery, and then I win the lottery and I don't pay it back, do they have a breach of contract claim against me?
I would say yes, because if you look at the law in Colorado, the consideration can be any sort. It can be very slight. Can be any sort of forbearance. Can be any sort of detriment. So, and then a promise for a promise can constitute consideration. So, if I'm promising to pay back for, and that would be a wonderful. I would love to be given $1 million like that. But I think if you look at the law, if I promise to pay back this money if I win the lottery, and they promise to pay that under that circumstance, I do think that's a contract. I do think that's adequate consideration. And then that's not exactly the same situation here. I would say that Mr. Brown certainly didn't win the lottery by getting hit by a drunk driver and having to undergo several surgeries and undergo all kinds of pain and suffering for what he got awarded here in a jury verdict. But I would just argue that the trial court was correct in formatting the judgment to the order, the opinion that was expressed in Pressey. I think Pressey was well reasoned, and and benefits the state as well as injured parties in these matters. And to go to the, unless, are there any questions about consideration or contract exception? Okay.
I have a question about the second issue. Are you
Yes,
turning to
yes,
that now?
please.
I had pointed out a section from Crossgrove that talked about admitting amounts paid evidence for any purpose as being an unjustifiable risk for the jury. And Mr. Campbell pointed out that the expert evidence here would have been based solely on amounts charged, not on amounts paid. Could you address that, please?
I would love to, Your Honor. If you do a close reading of Crossgrove, they're not just simply worried about evidence of the amounts paid. The reason they're worried about the amounts paid is because that would lead a jury to infer that there was, in fact, a collateral source. And collateral source evidence is, as the court says in Crossgrove, is readily misused by the jury and reduces the amounts that plaintiffs are awarded. And so I don't think you can look at it as narrowly as it's the collateral 10-135-10A keeps out only amounts paid. It's the factor of any sort of medical benefit. And if you take a look at Ms. Defoe's report, and unfortunately we can't actually take a full look at Ms. Defoe's report because it was not included in the record. All we have are just the first 2 pages of her report, but we don't get to see her actual substantive opinion. We don't get to see any of the spreadsheets or any of the facts that Judge Taylor looked at and relied upon in excluding her opinion. And actually, one of the cases we cited in our brief, it's Pagosa Lakes Property Owners Association v. Kaywood. It says, it cites another court, it says, when appellant has failed to provide a complete record, the appellate court will presume the trial court's findings and conclusions have evidentiary support. So I think that's something very important to consider here. How can this court, it's an abuse of discretion standard here, which means that it's either an erroneous application of the law or that, it was manifestly unfair or arbitrary or capricious. And I don't understand how this court can look at what Judge Taylor decided without actually seeing the report that he reviewed and was actually able to make the opinion on. But going back to your question, Your Honor, Ms. Defoe's report is not just the amounts that were charged. She would have had to go in, if you look at her 2-page letter, and that's all we have to look at here in this appeal, it says that what she would have told the jury was, I reviewed this national fee database, right? And I plugged in the CPT codes for each medical procedure that was performed, and that spit out this 70th, 75th percentile, and the 90th percentile. But what she would have had to explain to the jury would have been, well, in fact, these were amounts that were submitted to the health insurance companies from providers. So right there, you're presenting, because she would have had to explain how these numbers are computed. She would have had to explain CPT codes and what they're used for. Well, these are the billing codes used to where hospitals send these billings to health insurance companies. Again, you're violating you're violating what Crossgrove has established in that you must keep out collateral source evidence, and because it's just so subject to misuse by the jury. And so if Ms. Defoe is up there telling the jury, well, these bills are what are being sent to health insurance companies. How is the jury? What is the jury going to do at that point? They're going to infer there's health insurance, and they're going to get confused and they're going to get misled, and that was our main concern. Also, Ms. Defoe testified in the hearing before she was stricken that she could not actually say whether or not the bill charges were free. As you know, hospitals and medical providers have a contractual basis between two of them, and I think a lot of times the amounts that are billed are also determined by that contract. She could not say if there's any sort of contamination in her report or from the national fee database that she relied upon. Also, the database she was relying upon was kept by Optum, which is which is an arm of United Healthcare. Again, putting health insurance in front of the jury. And so our argument was, and Judge Taylor agreed with us. He initially struck her report, on a partial basis saying any collateral source information cannot come in, and I need to do a hearing to determine what it was not collateral source evidence. And after this hearing, he did in fact determine that there was appellant tries to characterize his finding as only one, on one basis. And I would argue when Judge Taylor looked at the collateral source rule in Crossgrove and Sonahara and Garden Schwartz, he looked at that and said, okay, we know under the collateral source doctrine that we're supposed to treat the plaintiff as if that he is uninsured, that there is no collateral source benefit. The tortfeasor is totally responsible for making the plaintiff whole. And we know under Crossgrove that the Supreme Court found that uninsured patients rarely receive a discount. So in that situation, if we're looking at this, Mr. Brown was hit by a motorcycle, hit while riding his motorcycle by a drunk driver, sustained several just broken bones, surgeries, lacerated spleen and liver. He had no choice as to what hospital he was taken to, and so I don't think Judge and I'm certainly as appellant said, we are not on the same page that we are not admitting that Judge Taylor erred in his analysis. I would actually argue that, in fact, the analysis Judge Taylor made was along the lines of the collateral source doctrine that's been developed here, and the fact that if you're supposed to treat someone like they're uninsured, and we know that hospitals rarely give discounts, then how can you then, if there's no dispute as the necessity of a medical bill, then how can you turn around and then ask them to go back to the hospital and say, hey, these are unfair. This jury here says that you actually charged me too much, when they have zero control over that. And so I don't think that was a departure from the standard. I think what the basis upon which he was relying upon was actually very sound. And also, I think a problem that the court had was under 403, that this evidence was substantially outweighed by the danger of unfair prejudice, because Mr. Campbell brings the fact that just because an expert doesn't reach an ultimate opinion doesn't mean that it's per se unreasonable. But at least in that analysis, the accident reconstructionist has actually provided an analysis and an opinion. Here, Ms. Defoe did not. All she did was simply plug CPT codes into a database and it spat out some numbers. She provided no analysis, no benefit, and the judge determined correctly that that was unfair to put from the jury and have the jury look through all of her evidence and have to speculate as to why one hospital is charging one and why another hospital is charging another. I see that I'm out of time, Your Honors, and thank you so much.
Thank you, counsel. Thank you to both counsel for your very helpful arguments. We appreciate it. An opinion in this case will issue in due course. That concludes our docket for this morning. The bailiff may call a recess.
All rise. The court will be in recess subject to call.
It was like a soccer game where you got injury time, so I got a little bit of extra. I'm sad you're not going to be there tomorrow for.
Too bad you